I know what it's like. So, I think it's important that we keep this information private.
To best serve disaster survivors, FEMA often must disclose the applicant's personal information to third parties. However, there are very strict guidelines on how this can be done. No disclosure without written consent is a cardinal rule within the Privacy Act. It states, no agency can disclose any record contained in a system of records to any person or to another agency except pursuant to a written request by or with the prior written consent of the individual to whom the record pertains. What is disclosure? It is the dissemination of PII by any means of communication, written, oral, or mechanical. In regards to disaster assistance, FEMA can only disclose information with the consent of the disaster applicant. Consent must be given prior to any release of information. Consent cannot be verbal, it must be written. It does not matter if the applicant's child, parent, best friend, the governor, or the President of the United States requests this information. In no way can any PII be shared or released without the written permission of a disaster applicant. In a valid written consent, the applicant must verify their identity, prove their identity, state who may receive information, and which information is to be disclosed. DHS regulations state that the applicant can prove identity by providing their full name, address, date and place of birth, and a sworn declaration of identity. To further safeguard an individual's identity, FEMA requires a unique identifier, such as a Social Security number or FEMA Registration Identification Number. FEMA does not have a written consent form. Anyone who wishes to receive information must provide written consent from the applicant. If an applicant wants a record of their own application, they are permitted to obtain it by submitting a valid written request. FEMA must keep the request on file as part of its disaster recovery assistance files. A routine use is an exception to the Privacy Act that allows authorized limited disclosures of an individual's PII to third parties without a written consent. Routine uses are published in the Federal Register and list the entities with which FEMA is authorized to share information: states, voluntary organizations, or other federal agencies.
For instance, it will share applicant information with a state agency that is providing housing assistance. And in order to prevent a duplication of benefits or in order to provide unmet needs of people, FEMA will share the information with this state agency without the written consent of the applicants, so long as they don't further disclose the information and they protect the information. If they don't do that, they will not receive similar type of information in the future.
There are routine uses in place for disclosing disaster applicants' information to voluntary organizations and Congress.
Oftentimes, a voluntary organization is very active and prominent in a community that has been hit by a disaster. FEMA will share information with these voluntary organizations because those organizations are able to provide additional or unmet needs to people who have been affected by a disaster.
FEMA employs individuals as voluntary agency liaisons or VALs, and they coordinate the disclosure of information when requested by the voluntary organizations. Congressional representatives often need to be aware of disaster data in their districts, so congressional requests for information are handled specifically by FEMA's Congressional Affairs staff.
Just want to let you know that we got your inquiry on your constituent with flood damage, Georgia 1858 event, and specifically I want to thank you for including the privacy release.
Requests can be made from Congress, but only if all of these requirements are met. The disaster applicant must request the congressional inquiry. The request can only be for that applicant's record, and the congressional representative submits the applicant's valid written consent or a Privacy Act release. To give the best possible disaster assistance, there are times when PII may be disclosed, but there are very clear and strict regulations governing its disclosure. The No Disclosure Without Written Consent rule states that the applicant must give specific written consent to disclose his or her information to a specific organization or individual. What is called a routine use is an exception to the Privacy Act's No Disclosure Without Written Consent rule. FEMA's routine uses must be published in the Federal Register. Any question should be forwarded to the Individual Assistance Program Office or to the Office of Chief Counsel.